Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Picture this. It's your very first day at a brand new job. You're excited, maybe a little bit nervous, and you're sitting on your couch just clicking through a seemingly endless portal of onboarding documents.
Yeah, we've all been there.
Right. You've got the tax forms, the direct deposit setup, health insurance elections, the, employee handbook acknowledgments. And buried somewhere deep in that mountain of digital paperwork, there's a document full of dense legal fine print. You scroll to the bottom, you check the box, you sign your name, and you move on.
You just want to start the new role.
Exactly. You want to impress your boss. But have you ever stopped to wonder what exactly you just signed away in that moment? And more importantly, if the company goes too far in that fine print, does a simple digital signature mean you've permanently surrendered your federal rights?
It's a scenario almost everyone listening to this has been through. You just want to get to the end of the module. But that exact everyday scenario is really at the heart of a massive legal collision. We're talking about corporate contracts versus federal law, and the implications are huge for anyone drawing a paycheck.
Which is exactly why we're focusing on the hidden power dynamics of employment contracts for today's deep dive. We're working from a brand new, hot-off-the-press legal opinion from the Fourth Circuit Court of Appeals. The case is called Natalie Thomas v. EOTech, LLC, and this decision was just handed down 4 days ago on March 4th, 2026.
It is a dense, incredibly revealing look at how courts view the balance of power between an employer and an employee.
And our mission today is to decode this complex legal battle. We're going to extract the vital takeaways about your workplace rights and explore why signing away those rights might not be as legally binding as employers want you to think it is. And I have to say, looking at your setup today, you are perfectly framed for this. Your backdrop looks like a towering bookshelf of heavy, leather-bound law volumes today.
Yeah, I figured we needed the heavy legal artillery for this one. When we're synthesizing federal appeals court decisions, civil rights law, and state employment regulations, a solid library backdrop just feels necessary.
It sets the perfect mood. Let's get right into the story of Natalie Thomas. This all starts with a timeline, and the timeline is what trips everything up. Natalie Thomas was hired by a company called EOTech. But before she officially started working, she signed an EOTech drafted document that contained something called a limitations agreement.
Right, and the specific detail in that limitations agreement is the crux of the entire dispute. The document stated that, as a condition of her employment, she agreed not to file any action or suit relating to her employment more than 180 calendar days after an incident occurred.
So 6 months.
Exactly. It specifically included claims for employment termination and discrimination. She was signing on to an incredibly strict 6-month expiration date for any potential lawsuit against the company.
Okay, let's unpack this because the math here gets incredibly tricky, incredibly fast. On November 9th, 2022, Natalie Thomas was fired by EOTech. The clock immediately starts ticking. Now, she doesn't just run to a courthouse and see the next day. On February 23rd, 2023, she files a charge of discrimination with the Federal Equal Employment Opportunity Commission.
The EOC.
Right, the EEOC and the Maryland Commission on Civil Rights. So I'm looking at the calendar here, and from her firing to her filing, that is exactly 106 days.
Which leaves her with 74 days remaining in her 180-day window.
Mm-hmm.
But the contract she signed contained a very specific caveat. The agreement stated that if she was required by law to file a charge with an administrative agency like the EEOC before filing a lawsuit, the 180-day clock would be tolled.
Tolled, meaning paused, like hitting a timeout button on a stopwatch.
Precisely. While the EEOC conducts its investigation, her 180-day countdown is frozen at 106 days. The federal agency takes over, reviews the facts, and eventually finishes their process. On September 7th, 2023, the EEOC sends her a right to sue letter.
And that letter is basically the agency officially ending their involvement, right?
Yeah, they're telling the employee they are now cleared to take the matter to a judge.
So the pause button is lifted and the clock resumes. Thomas then files her federal lawsuit on December 6th, 2023. That is exactly 90 days after receiving the letter.
So let's do the final calculation. She used 106 days before the EEOC filing.
The clock paused.
Then she used 90 days after the EEOC finished. That equals 196 countable days.
I don't know about you, but I didn't bring a calculator to my first day of work to figure out these kinds of formulas.
Nobody does.
But EOTech certainly did the math. They looked at the 196 days, pointed at the 180-day agreement she signed, and argued that she was 16 days late. They claimed she breached the contract and her case should be closed. And the wild part is the district court actually agreed with EOTech and threw out her entire case over those 16 days. How can a private contract, literally just boilerplate onboarding paperwork, override major federal laws like Title VII of the Civil Rights Act and the Age Discrimination Employment Act?
That is the exact question the Fourth Circuit Court of Appeals had to untangle. To understand why the Fourth Circuit ultimately overturned the lower court's decision, we have to look at how Congress built these federal laws in the first place. Congress created what the court calls an intricate remedial scheme for Title VII and the ADEA. These statutes are not designed for you to just get wronged and instantly drag your employer in front of a federal judge.
There's a mandatory waiting room you have to sit in first.
A very intentional waiting room. The law specifically mandates that you must go to the EEOC first. Under this federal scheme, employees are given a floating window of 180 to 300 days just to file that initial EEOC charge. The window floats based on something called cooperative federalism principles.
Let's translate that a bit. Cooperative federalism is that basically the federal government saying, hey, if your local state agency has their own laws and wants to take a crack at investigating this first, we will give you more time.
That's a perfect way to put it. It's the federal government honoring state-level processes. So right off the bat, Congress is giving you up to 300 days just to start the paperwork. Once the EEOC has the charge, the statute says they're supposed to try informal methods of conference, conciliation, and persuasion.
Which means sitting down in a room, looking at the facts, and trying to get the company and the employee to shake hands and settle the issue without clogging up the court system.
Yes. They want to avoid a lawsuit entirely if possible.
Yeah.
But if conciliation fails and they send you that right to sue letter, the statute explicitly grants you another 90 days to officially file your lawsuit. So if Congress guarantees you at least 180 days to file the charge and then another 90 days to sue after the investigation, the absolute minimum time Congress allows for this two-step process is 270 days. What's fascinating here is how a 180-day private contract fundamentally breaks Congress's math. The Fourth Circuit pointed out that the inevitable impact of EOTech's limitations agreement is to shorten the total time Thomas has to complete those two distinct tasks. The contract literally cannot function without forcing the employee to either shortchange their time to file with the EEOC or shortchange their time to file the lawsuit afterward. You cannot physically fit 270 days of federal rights into a 180-day corporate box.
It's a rigged game from day one. If you take the full time the government gives you for step one, you automatically violate the corporate contract for step two.
And if we connect this to the bigger picture, the court emphasized that this entire system is fundamentally designed to protect the layperson. The Supreme Court has noted in previous cases like Holowecki and commercial office products that Title VII and the ADEA are meant to be navigated by everyday people. Pro se filings, which means an individual submitting the paperwork themselves without hiring an attorney, are expected to be the rule, not the exception, at the charge filing stage.
When you think about the average person who just got fired, they're stressed, hunting for a new job, trying to figure out how to pay rent. They do not have a legal team on retainer to decipher the timeline.
Exactly. The EEOC's own public website tells citizens they have 180 to 300 days to file a charge. The Fourth Circuit noted how absurd it is to expect an everyday employee to cross-reference their old, signed HR documents against federal statutes and the EEOC website to calculate a customized hidden deadline. It would seriously impair the navigability of the entire civil rights system.
Here's where it gets really interesting. EOTech actually tried to defend this mathematical trap in court. They argued that there is no problem here because employees like Thomas should just use the time while the EEOC is investigating to hire lawyers and prep their lawsuits. They basically told the court, use the pause time to get your legal drafted so the minute you get the right to sue letter, you can file it the next day.
The Fourth Circuit did not take kindly to that argument. The court pointed out that telling employees to instantly lawyer up and prep a lawsuit completely destroys Congress's primary goal.
Which is conciliation.
Right. The whole point of the EEOC process is to foster cooperation and voluntary compliance. Forcing an employee to aggressively prep a lawsuit in the background while supposedly participating in a voluntary, informal resolution process is entirely contradictory to the law's intent.
But how does that actually play out in the real world? If I'm forced to rush my lawsuit because my 180-day contract is ticking down, doesn't that just put an insane amount of pressure on the federal agencies trying to help me?
It does, and the court laid out a fascinating hypothetical scenario to illustrate this exact problem. They asked us to imagine two different employees, Ann and Bill. Both of them filed timely EEOC charges against their employer. The EEOC investigates both and finds that both cases have merit. But, as is often the reality with government agencies, the EEOC only has the resources and budget to pursue one of the cases themselves in court.
They have to make a tough choice between the two.
Ordinarily, the EEOC might pick Ann's case because the facts are more egregious, or maybe her case establishes a broader legal principle they want to enforce. They would sue on Ann's behalf and give Bill a right to sue letter so he could pursue his own case privately. But what if Bill signed a 180-day contract like the one EOTech used? The EEOC might realize that Bill's personal countdown clock is almost at zero. His window is basically shut.
Oh, wow. So the agency is suddenly dealing with a ticking time bomb.
Yes. The EEOC might feel pressured to take Bill's case just to save his claim from completely expiring, even if Ann's case is objectively stronger or more important for the public interest. The Fourth Circuit ruled that Congress never intended for private corporate contracts to distort how a federal agency allocates its resources or makes enforcement decisions.
It is wild to think about how one signature on an onboarding portal could theoretically warp the entire federal enforcement mechanism. Now, to make sure we're looking at all sides of this impartially, EOTech did not just invent this 180-day concept out of thin air. They argued they should win based on previous legal precedent, pointing to cases like the cotton yarn antitrust litigation and a dispute involving the Atlantic Coastline Railroad.
Those citations are important to cover because they show EOTech's legal strategy. EOTech argued that in the cotton yarn case, the Fourth Circuit had previously established a general rule that statutory limitations periods can be shortened by an agreement, as long as the new period isn't unreasonably short. In that specific case, shortening a limit to 1 year was permitted. They viewed their 180-day contract as a valid affirmative defense.
Let's clarify that term for a second. An affirmative defense is basically a legal rule that lets the defendant win the case, even if everything the plaintiff is alleging is technically true, right? Like a get-out-of-jail-free card based on a technicality.
That is exactly right. EOTech was saying, even if we did discriminate against her, she signed the contract, so we win. But the court dismissed their reliance on the cotton yarn precedent because the context was entirely different. Cotton yarn was about arbitration under the Federal Arbitration Act, the FAA.
Right.
The FAA has a very strong, legally favored policy of enforcing arbitration agreements. Allowing a shortened timeline to initiate a private arbitration is one thing, but completely stripping an employee of their substantive right to access a federal court under the Civil Rights Act is a completely different beast.
And what about this railroad case? You were telling me they tried to compare a massive railroad union with a fleet of lawyers to Natalie Thomas sitting at her kitchen table reading a PDF.
It was certainly a stretch. The Atlantic Coastline Railroad case fell under the Railway Labor Act. That specific piece of legislation was uniquely designed to give unions and carriers the explicit power to negotiate timelines and settle disputes locally. The statute itself empowered the two groups to haggle over deadlines. Title VII and the ADEA, however, contain no such empowerment. They are built for a uniform, nationwide enforcement system meant to protect individuals.
So the precedents EOTech tried to rely on were essentially comparing apples to oranges. The Fourth Circuit determined you cannot use advance agreements to render a timely federal civil rights suit untimely. So what does this all mean? Did Natalie Thomas win her case and get her job back?
Here is the twist ending, and it's a sharp one that completely flips the narrative. Everything we've discussed so far has been about her federal claims under Title VII and the ADEA, but Thomas also sued under state law specifically, the Maryland Fair Employment Practice Act, or MFEPA.
And because her case was in a federal court, the federal judge still has to apply Maryland state law to the Maryland-specific claims.
And under Maryland state law, the rules of the game change entirely. Maryland uses something called the Seacone standard. Under this standard, modifying time limits in a contract actually is allowed, provided it meets three specific rules. First, there can be no controlling statute that specifically forbids it. Second, the modified time limit must be reasonable. And third, the agreement cannot be subject to other defenses like fraud, duress, or misrepresentation.
This raises an important question. Was a 180-day limit really considered reasonable under Maryland law? Because we just spent the last 10 minutes outlining how completely unreasonable and mathematically broken it is under federal law.
This is where we have to dive into the 5 non-exclusive factors Maryland courts use to determine if a shortened time limit is reasonable. They look at 1, the length of the shortened period itself, 2, the relative bargaining power of the parties, 3, the subject matter of the contract, 4, whether the shortened limit applies to both parties equally or just the employee, and 5, whether the provision violates public policy.
Let's talk about factor number 2, the relative bargaining power. When you're sitting there on day 1, staring at a screen full of onboarding documents, you have zero bargaining power. You can't just cross out a clause and say, actually, I'd prefer 270 days, thanks. You either sign it or you don't get the job.
It's a massive imbalance of power, and it's a very strong argument she could have made regarding whether the contract applied to both EOTech and herself equally. But here is where the procedural realities of the legal system come crashing down. The Federal Appeals Court ruled against Thomas on her state claim, not necessarily because 180 days is perfectly fair or reasonable under those 5 factors, but because of how the appeal was argued.
Wait, she lost because of how the legal argument was formatted?
Yes. In her appeal brief, the written document her legal team submitted to argue why the lower court was wrong. Thomas simply argued that the time was unreasonably short. She completely failed to reference those 5 specific Saccone factors or make any detailed argument about why the lack of bargaining power or the one-sided nature of the contract cut in her favor.
That is brutal.
Because she didn't preserve those specific arguments for review, the federal court said they had no choice but to affirm the dismissal of her state claims. The court even explicitly noted in their opinion, "We make no ruling about whether someone in Thomas's position could have made a winning argument if they had actually utilized the right factors."
It really highlights how unforgiving the legal process can be. You can have a completely valid point about how unfair a contract is, but if you do not argue it using the exact right legal framework on appeal, you lose.
So the final result of this entire legal saga is a split decision. Thomas's federal claims under Title VII and the ADEA are fully revived. The Fourth Circuit vacated the summary judgment on those claims.
And just to clarify for everyone, vacating the summary judgment basically means the appeals court threw out the lower judge's decision to end the case early. Thomas actually gets her day in court to fight the federal discrimination charges.
Correct. She gets to go back to the district court and proceed to a potential trial on the federal level, but her state claims under the Maryland Fair Employment Practice Act are completely dead. The judgment dismissing them was affirmed due to that procedural error.
What an absolute roller coaster of a deep dive. To synthesize all of this for you listening, the major takeaway here is that federal laws like Title VII and the ADEA are heavily guarded by the courts against corporate contract overreach. A company cannot just slip a 180-day expiration date into your onboarding paperwork and expect it to magically erase the careful, multi-step remedial process that Congress created to handle civil rights violations. The courts recognize that you are a layperson, not a legal scholar, and the system is designed to give you the necessary time to utilize the EEOC's conciliation process.
The flip side of that takeaway, however, is just as vital. State-level protections might be much, much more vulnerable to the fine print. While federal law held strong against this mathematical trap, Maryland's state law allowed the limitation to stand, partially due to the nuances of state-level standards, and partially due to a misstep in appellate strategy.
The next time you are sitting there clicking Accept on page 42 of your new job's onboarding portal, remember this case. A standard corporate contract cannot necessarily overwrite federal law, but it can complicate your life immensely, and it can absolutely jeopardize your workplace rights on the state level if you aren't careful. I want to leave you with the lingering question to mull over as you go about your week. Think about the sheer scale of this ruling. If federal appeals courts are now actively deciding that standard 180-day limitation clauses are fundamentally incompatible with federal regulatory schemes, what other standard boilerplate clauses are hiding in millions of HR files right now across the country? What other standard procedures that everyone just assumes are legally binding are actually legally void, just sitting there in a filing cabinet waiting for the right employee to finally challenge them? Thank you so much for joining us on this deep dive. Stay curious out there.
Hey, it's Mark, and thank you for listening to this episode of the Employee's FIBA Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.